All right, welcome back, everybody. We got a few updates, so let's just get right into them. From a couple videos back, if you remember, we went into Wes's motion to stay, and the judge gave him a hard deadline there of October 27th that they're willing to extend the stay, basically meaning that they'll put the civil case on pause so that he can hopefully work out his criminal case. But it was specific that if that criminal trial did not occur by October 27th, that stay was up. Well, as of filming, today is October 29th, so we haven't seen any requests for an extension. We haven't seen anything to the contrary, so it's safe to say that now the civil case is fully active and on for Wes, which is a big problem. It's something we're going to get into today, as well as some other filings that Nicholas Delis made, as well as the plaintiff, Hakeem Ibrahim. All right, so quick context here. Again, as you guys remember, there was that court order with the October 27th deadline. Again, that has come and go. So what does that mean for Wes? That means now everything's fair game in the civil trial, or in the civil case. As we talked about, the civil case, you're subject to interrogatories, depositions, where you're under oath, and that can put him at risk in his criminal trial, in his criminal case. Again, now it's all fair game, so it's going to be all sort of eyes on him. As to his next move, I'd anticipate they will try to expedite that criminal trial as much as possible so that he can minimize his exposure. Now, aside from Wes, we saw his co-defendant, Nicholas Delis, and his counsel made some filings, so we're going to get into that, as well as a motion to compel that was filed by the plaintiff, Hakeem Ibrahim's, attempting to force, basically, Elevate Fitness to start answering the interrogatories and stopped objecting. And we'll get into exactly why they requested that and some of the almost laughable answers Elevate Fitness was giving to those interrogatories. At first, so we see a motion to dismiss the cross-claim here. This is filed by Nicholas Delis, and he's essentially trying to dismiss the claim that Elevate Fitness is filing against him. So Elevate Fitness is attempting to hold Nicholas Delis responsible. Nicholas Delis here is saying, no. Hey, listen, this is not on me. This is on you guys. This needs to be dismissed as to him. So these are cross claims, meaning that even the defendants can make claims against each other. And so here we see it states. The cross-claim fails to state a cause of action upon which relief may be granted. The pleading asserts conclusory allegations about specific facts connecting Mr. Delis to any cognizable claim for indemnity or contribution. Basically, what they're saying is that you made a bunch of conclusions in this, but you provided no evidence. You're doing a lot of finger pointing without facts or elements. So these are what we call conclusory. It's just a conclusion. You're not showing any evidence as to how I actually did that or pointing to any evidence that would actually show that. So again, here Nicholas is saying, listen, you can't just point fingers in an attempt to shield yourselves from liability. This is not on me. This is on you guys. And by you guys, I mean Elevate Fitness. Now, indemnity. So common law indemnity in Florida is available only where the party seeking indemnity is wholly without fault and is exposed to liability solely due to a special relationship such as vicarious liability. No such relationship is alleged here. So essentially, in English, what Delis's counsel is saying is that the only way that you can indemnify me, basically point the finger at me, is if you're wholly without fault. And he's speaking to Elevate Fitness. So he's saying that because you're not wholly at fault, common law here in Florida says you can't point the finger and try and indemnify me and bring me into this action. Now, we also see how he goes into, there's also not a special relationship here, such as vicarious liability. What that means is sometimes if there's an employer-employee relationship, there'll be vicarious liability. And what that means is, for example, let's say it was somebody that worked at the gym or a trainer at the gym that had actually attacked Hakeem Ibrahim. There'd be a vicarious relationship or vicarious liability with the trainer that attacked him and the gym Elevate Fitness for having employed that person. So what Nicholas' counsel is saying is no relationship exists. I wasn't working for Elevate Fitness. There's no connection here at all with me to Elevate Fitness. He also goes into contribution. It says contribution is not available under the cross-claim as pleaded. The cross-claim fails to identify a statutory or legal basis that would permit shifting or apportioning liability to Mr. Delis on the alleged facts. Basically, they're saying you haven't shown in any way why Nicholas Delis here would be responsible or have to contribute in any way to any potential judgment against Elevate Fitness. And so the short of it is, here his counsel is asking that the court dismiss the cross-claim, meaning the claim made by Elevate Fitness against Nicholas Delis, and dismiss that in its entirety. So here's the takeaway from that. If granted, Delis now stops fighting Elevate Fitness, his co-defendant, and can focus on the plaintiff, Hakeem Ibrahim. Now, if it's denied, it's pretty much friendly fire discovery, where everyone subpoenas everyone. Now, another interesting development, here we see there was a proposal for settlement that was filed by, again, Nicholas Delis' counsel with regards to plaintiff Hakeem Ibrahim. So here we see it says that defendant Nicholas Delis hereby gives notice that he has served upon plaintiff Hakeem Ibrahim a proposal for settlement pursuant to a bunch of statute bullshit. Okay, so basically what this means is that in Florida, this is their version of offer, or judgment lever. Okay, so what that means is that pursuant to Florida law, if they reject this offer and fail to beat it later at trial, now the fee shifts. So what does that mean? That means whatever offer here that Nicholas Delis is making to Hakeem Ibrahim, let's say, for example, this is just totally throwing a number out there. Let's say it's $50,000. Now, if they deny that offer and go to trial and they don't at least get $50,000, the fee shifts, meaning that now they're responsible for the other's attorney's fees. So you're sort of, in a sense, rolling the dice a bit if they deny it and go to trial, because they're betting that they'll get more for sure at trial. So it'll be interesting to see how this plays out. But it's our first sort of glimpse at how a settlement between some parties may occur, and how some of these special rules with regard to, especially in Florida. So if they reject it again and they go to trial, they'll have to pay for the other side's attorneys. And again, given how long this is dragged out, that's not going to be a small feat. I mean, it'll easily be in the six figures of attorney's fees. So again, if the plaintiff gambles and doesn't beat the number, a fee tab will follow that verdict home. All right, now most interesting, in my opinion here, we see that plaintiff Ibrahim files a motion to compel the answers to interrogatories. So Hakeem Ibrahim served upon Elevate Fitness interrogatories, which are questions that they have to answer under oath. They're written questions they sent to them. They have to respond back under oath. And essentially, the excuses that Elevate Fitness has come up with a lot of some of these questions that were asked of them, I don't want to make any speculations, but it doesn't sound like an innocent party. So we'll go through some of the specific. We'll go through a couple of the actual interrogatories that was sent to them and what their objections were. But like I said, essentially this is the plaintiffs asking the judge, hey, they're not doing what they need to do. You need to make them do this. They need to answer these questions, and the objections that they're making are fanciful. They're a joke. So again, we'll get into that here shortly. We'll have some of those these are the actual interrogatories and Elevate Fitness's answers. All right, so we see here it says plaintiff served the interrogatories on so-and-so date. The responses were due on so-and-so date. And to date, defendant, Elevate Fitness here, has failed to serve verified complete responses. So basically what they're saying is they're objecting nonsensically and not answering the questions. They go on and they say defendant's responses consist largely of boilerplate, non-particularized objections, for example, vague and broad, ambiguous, unduly burdensome, without factual support, and otherwise fail to provide the information requested. Several responses are evasive or non-responsive, and no verification has been provided. Basically, what they're saying is they're not answering even the simplest of questions. They're evading these questions, and they're making nonsensical objections in hopes of having to not answer some of these questions. And again, we'll see these aren't the most difficult questions. So we see here as a sample, hopefully we can put up a picture here of it. One of the interrogatories was, identify all employees or agents on duty at Elevation Fitness on the date of the incident who witnessed or responded to the incident involving plaintiff, including their full names, job titles, and contact information. Now, Elevate Fitness counters and says, objection, vague, overbroad, compound, unduly burdensome. Without waiving objections, defendant refers generally to records in its possession. Basically saying, we're just asking for the names of your employees that were present in there. And they're saying, no, this is vague, this is too burdensome, this is asking too much. We go on to see that it says that plaintiff's counsel attempted in good faith to resolve these issues without court intervention, including correspondences on various dates, and defendant declined to supplement. So basically they're saying, hey, we tried to fix this like adults. They didn't want to buy in, so now we need to escalate. Now, importantly here in the relief requested, it says the plaintiff requests an order compelling defendants to serve verified complete answers within 10 days, deeming unsupported objections waived and awarding plaintiff reasonable attorney's fees and costs incurred in bringing this motion. Basically, they're saying they're wasting everyone's time here. We need to make them pay for it literally in order for them to start taking this seriously. So we need them to answer within 10 days full sentences to all the questions, and there are 25 or 30 of them. And they also need to front the bill for all this excess work we've had to do because they've been evasive, let's say, at minimum. All right, so how do these all interlock? So Delis' motion to dismiss tries to delete the side quests he's got, so he's not fighting other co-defendants. His proposal for settlement adds some fee leverage, again, if the plaintiff can't meet that reasonable number. And we see here with the motion to compel these interrogatories, we're gonna start seeing actual answers from Elevation Fitness and seeing what their defense is going to consist of, because the judge is not going to play around. The judge is going to make them answer these questions, and they're going to put them on a clock. They're not going to give them forever to answer these questions. So it'll be interesting to see how they're attempting to waive their defense. I don't really see that they have one, but it'll be interesting to see how it plays out. And most importantly and interesting, now the clock's on Wes too. So he's now subject to the same interrogatories, depositions under oath that Elevation Fitness was. Now I assume he'll try and Kurt the same way that Elevation Fitness did, but I think the judge will set a real example here, setting a hard deadline for Elevation Fitness that again will be a reminder to Wes that things are real now, and he's got to start taking this seriously, and he's going to be under oath fairly soon, if not in his criminal case, then certainly now that it's live in the civil case. So again, everybody, it'll be interesting to see how this plays out. Again, feel free to tune in. We'll try to keep you up to date on all these legal findings and break them down as simply as possible, and appreciate all your support.